would be when or if the attorney says, well, my notes reflect. All right, when an attorney says, usually a defense attorney would say this, when they say my notes reflect, I immediately would object, because that's not a question. You saying my notes reflect is not a question. So anything that follows after that is you're kind of trying to insert a fact into a question. So this is an example. Defense attorney to the plaintiff. Oh, well, my notes reflect that you hurt your back in middle school when you fell off the swing set. Okay, well, I would object right there and say, objection, we don't care what your notes say, and I don't know what your notes do say. I don't know if your notes actually say that or not. I don't know if there's a picture of pink elephants on your notepad, and unless you want to put your notes into evidence, you're not going to say what your notes say, because that's referring to a document, not an evidence, and saying what it says. That would be the way to handle that situation, and that would allow the attorney to ask the question differently. They could say, did you hurt yourself on the swing set in middle school? But they can't say my notes reflect, because that's technically, well, it's false almost certainly, even though you can never verify it. They won't ever let you see their notes. But that's why you can't say it, because you can't see their notes. So if they ask you that question and if it's not true, then the answer is no. You just say, no, I didn't hurt myself on the swing set. The wrong answer would be, oh, well, if your notes say it, then it must be true. You'd be shocked at how many times I hear a client say that at a deposition, and I can't believe it. I say, if their notes say it, it must be true. They're the defense attorney for the insurance company hired to devalue and hurt your case. They're not necessarily going to be giving you truthful and accurate information. So I say the answer is never if your notes say it must be true. Never, ever, ever say that. If it is true, you say I recall that. If it's not, you say either I don't recall or it definitely didn't happen. One of the two. So those are some of the big things that can really hurt a case, because if you say if your notes say it must be true, you've just made a fabrication into a reality, because that never even occurred, but they just made it up and you just committed to it. So now it's now true. So be careful of that. Another thing that I hear a lot of is, I object to, is a foundation question. When a defense attorney lacks foundation in their questioning. So for example, let's just assume it's a rear-end car accident, right? You're at a red light and the defendant fails to stop in time and hits you while you're stopped at the red light and hurts you. That's the case. So those are the facts. At the deposition, let's imagine that there hasn't been any testimony about your vehicle moving at all. The defense attorney says, so how fast were you going when you got hit from the rear by my client? Objection. The objection will be formed, but it's really because there's no foundation. It has not yet been established that you were indeed moving when you got hit. So you can't ask her how fast she was going. You haven't even established that she was moving at all. So first they have to establish that you were moving before they ask you how fast you were going. Those are typical foundation question objections. They have to establish certain facts before they can jump to another question. Again, that's just a very simple example of it. So typically the attorney would object, you would stop dead in your tracks. Attorney would say, objection form, hasn't been established that she was even moving. And then the defense attorney would likely say, oh, right, were you moving when the accident happened? No, I was stopped. Oh, okay. So that cuts that right there. Another thing to keep in mind is if they ask you, if you had an MRI of your back, for example, they may say an improper question. What did the MRI show? Objection, I would object. What's the objection? Well, she's not a doctor, she's not a radiologist, and she can't interpret film. She's not qualified, so you can't ask her what it shows. That's where I would cut it off right there. Or what they could ask you, if they're a more skilled defense attorney, they would say, did your doctor tell you what the MRI showed? Did they tell you what the MRI revealed about your injuries? That's okay. That question's a proper question. You may be thinking that's hearsay. That's true. However, hearsay does not apply to depositions. You can ask hearsay questions at a deposition. It is allowable.